The defense resting in the felony gun case against Hunter Biden. The president's son ended up not testifying in his own defense. ABC News senior national correspondent Terry Moran joins me now from the courthouse in Wilmington, Delaware, along with ABC News legal contributor Brian Buckmeyer. Terry, what's the latest from court?
Well, Diane, both the defense and now the prosecution have rested. The defense, after a long consultation, Hunter Biden was questioned by the judge in a sidebar with the sound muffled from the rest of us. It seemed that was the moment at which the decision was confirmed to the judge that Hunter Biden would not take the witness stand. And then the defense rested its case based on its cross-examination of some of the prosecution's witnesses and a few of its own witnesses as well. And then the prosecution called one more witness, an FBI agent, who offered some metadata from Hunter Biden's phone that placed him at a 7-Eleven here in Wilmington, where in his own book he acknowledged that was the kind of place that he would go to buy drugs just a couple of days before the purchase of the gun, just an effort to shore up the prosecution's case that Hunter Biden was not clean, was still abusing drugs at the moment or right up until the day of the purchase of that weapon. And so both sides have now rested their case. Closing arguments are next.
Brian, what do you think went into the decision to not have Hunter Biden testify?
So ultimately, whenever a person decides to or not to testify, it's their right to. An attorney can advise them, but it's ultimately a defendant's decision. I think for a case like this, there's no one, I think Terry has said this in the past, there's no one who can directly testify as to Hunter Biden's thought process, his specific drug use and his private and personal kind of quarters other than Hunter Biden. And so in a case where you don't have to prove your innocence, but the prosecution has to prove your guilt, I think putting him on the stand could have been potentially one step forward and two steps back when you think of a cross-examination against Hunter Biden, not only from a criminal standpoint, but also just from an embarrassment standpoint for himself, his family, including the current president.
Terry, how vulnerable do you think the defense is, especially with Naomi Biden's testimony not quite going as the defense had hoped? How vulnerable do you think they are now without Hunter Biden testifying in his own defense?
Well, there's no question that the prosecution presented a great deal of evidence about Hunter Biden's drug use before and after the day in question in this case, October 12th, 2018. But as to that day, they don't have any direct testimony or evidence that he was abusing drugs. But it's pretty close in the days around, and I expect the prosecution to say in their closing arguments, use your common sense. Was this person truly not abusing drugs? Would you want your own relative to be purchasing a gun if this was the pattern in their life? And I'm now being handed a note. So judge just is reading the jury instructions now. And there's one jury instruction I want to get to. That's the word knowingly. The law says that the government must prove beyond a reasonable doubt that Hunter Biden knowingly lied on that form when he said he wasn't abusing drugs. And the judge will define knowingly to the jurors in these words. The government must prove beyond a reasonable doubt that the defendant was conscious and aware of the nature of his actions and of the surrounding facts and circumstances as specified in the offenses. So there's a little bit of room, I'd ask Brian on that, for the defense to make the case to the jury that given that level of proof the government must have, that they have to prove what his state of mind was, that he knowingly lied on that form. Maybe there is some reasonable doubt that the defense can raise with at least some of the jurors. And
of course, like any other case, the burden of proof here is on the prosecution. Brian, closing arguments are set to begin soon. What are you watching for there?
I'm looking to see how the defense both explains knowingly, but also Hunter Biden's state of mind, and probably also add in the prosecution's burden. In a case like this, for me, where I think, and Terry pointed out, that the dots are pretty close. We know about Hunter Biden's drug use before October 12th, and we know about Hunter Biden's drug use after October 23rd. But for that 11-day period, there's no direct information. And for me as a defense attorney, I would say the prosecution or the government in this case came up and said it's their burden to prove the case beyond a reasonable doubt. So why are they now asking you to connect the dots? If they couldn't connect it for you, why is it now your burden? And I think in an argument like that, the defense would win, because for the government, it's highly suggestive that Hunter Biden did, in fact, lie on those documents. It's highly suggestive that he used during that time. But highly suggestive isn't the standard in a case like this. And so I'm interested to see how both sides argue that.
All right, Terry Moran, Brian Buckmeyer, thank you both.